welcome, please. Thank you so much. And obviously, people do not realize you can get stuck into a bad investment sometimes, right? And it's interesting, how do we navigate through the whole process? So what I thought, if you could tell, what challenges have you seen while planning an exit investment for India?
Let me start by saying this is all hypothetical because we don't have any bad investments in India.
Yeah.
Okay. I mean, I don't think India is different to other places. The fundamental challenges, I think, fall into two buckets as I see it. The first is the sort of the universe of promoters and partners. I think the two are related, frankly. And I'll come back to it, but I don't know that it's any different in India as to anywhere else, as to sort of the natural propensity for mischief. But I think, and this is the second point, that the difference with India relative to other markets that we see is the quality and the ability of the judiciary really to enforce contractual documents. And I think what you see is where there is the inability to resort to the judiciary, the sort of the systems of carrots and sticks that normally keep people in place sort of disappear, and frankly, people are somewhat emboldened to behave in ways that are counterproductive to getting what you set out to do at the outset done. So I think one of the things you can do, of course, is arm yourself with good lawyers. It's one good thing to do, but I frankly, that alone, the quality of your drafting, the quality of your documents, is really not enough. I think what we find is you need to have, on top of the fact, very good diligence as to who you're actually doing business with when it comes to an exit. I think you need to keep two things in mind. The first is, if you can, at the point in time when you're structuring these investments, you want to have some leverage other than the stick of a document and enforceability. So whether that's something in the nature of a relationship or something in the nature of security over actual collateral. And then, ideally, you want to have a little bit, you want to leave something on the table so that there's something to play for at the end, because frankly, it's difficult, as I say, just to enforce your documents. So it's a combination of tactics, but we think leaving a little bit of money on the table will help you steer people to the right conclusion where they don't want to do that. Obviously, where they do, you don't have that problem.
Pratibha, how long before should you be planning your exits, and what kind of safeguards need to be put in place for smooth exits?
Okay. First of all, I think it's a good sign. I'd like to see it as a good sign that the room was full when we were looking at raising funds in India and investments in India. And, 2 years ago, when we talked about disputes in India, the room would be full. Now it's not. So hopefully this is a mind change, then we're back to looking at investments in good old days. To answer your question, we're still looking at a lot of exits. A lot of our clients are in exit mode right now. I think it's a predominant part of our business, just as busy as investments. And the one thing that we've seen consistently, where we've not advised the client in the investments and, they're coming to us for exits, is that we just wish they thought of it earlier, right? Because the one situation is where there's no dispute, but you still need to think of an exit structure based on change in laws, right? There's a lot that has happened in the 4 or 5 years when you invested versus today in terms of tax changes, regulatory changes, and how you can do an exit. In a dispute situation, that gets further intensified because not only would promoter use the change in regulations as the stick on your head not to allow you exit, but will create 20 issues of different nature if he's not willing to give you the right exit. Even though today puts are considered enforceable by the government, even around issues, even with that enabling provision, you still have the promoters looking at various other means, whether it's filing disputes where there are none, going personally after the directors where there's no need to. We've seen various strategies being employed by the promoters to delay your exit because they know that you have a time commitment by which you have to exit. So they play the slowing down game in India, which Chris was talking about, because courts lead to delays because you don't necessarily are able to get out of courts quickly. And because of that, if they file something right before you're about to exit, it's that much more delay for you to exit, and you will leave money on the table just to get that exit. If you know that there's a potential dispute or it's going to be a difficult promoter, you have to anticipate those issues. And 2 to 3 years before your exit, start thinking about what are they. I mean, by now we pretty much know on the street there are certain. It seems like these promoters all talk to each other because they all apply the same tactics. They have different lawyers, but they apply the same tactics. So you know pretty much what they're going to try and use, and you've got to anticipate it and start working towards your exit much, much more before.
Yeah. What about forensic analysis, Deepak, before and after making investment? Can you tell a little bit about that?
Sure. So again, from a life cycle point of view, there's a lot of effort that goes into doing a background check, due diligence on an investment before the money's been put in. So you'll obviously be doing the legal due diligence, and you know where to go. And you'll be doing your financial due diligence, and then you need to do the proper background reputation check to understand who are these people, what is their background, what other issues have they had, what kind of. Well, ideally, there shouldn't be that many red flags because you would have filtered them out, but then you are dealing with some kind of yellow flag, which could be there's a distant political relationship, there's some cash in the system, there's been a propensity of litigious nature of the promoter, or there could be something else from their previous business or previous career that could be of concern. So when you are made aware of these, let's say, yellow flags, it's as part of going in with your eyes open, it helps to take those factors into account when you're putting your legal contracts and shareholder agreements together. So this is good, valuable, actionable intelligence for you to then structure the arrangement. And then you also then get a sense of, do I need to watch and monitor this investment more closely or less closely in case you're in a minority situation? So so what we do see is generally there's a lot of effort that's made before, and it should be, because at least you're collecting data up to a certain point. Beyond that, there should be a level of monitoring and information gathering all the way through, so that at least you're getting the right kind of material to help legal counsel build the case, saying that during the course of the investment, you gave us all this, you made these statements, you made all these claims, and these were all exaggerated. So it helps you in case things go wrong. So part of the process should be to gather information during the relationship, so that in case things go wrong, at least you've got something to start from. So let's look at it this way, that the pre-transactional reputational due diligence has told you what's happened before you came on the scene. Then because you're on the scene, you're collecting the necessary information. And then after, when things are turning sour for a whole variety of reasons, because sometimes what we've seen is that promoters are very clean, but then once they've got the money, things change, and that becomes an area of concern. So at least you've got the right kind of information to reach out to legal counsel to help you support in developing the strategy, from whether it's arbitration or otherwise to a negotiated settlement, to reach out with the right kind of data to have some information, some data to build your case stronger than what would be if you didn't even bother asking them how they were running their business. So that's what our suggestion would be.
Yeah. But once you sense a potential dispute, Weber, what should be pre-litigation strategy?
Yeah, thanks, Nishime. I think as Pratibha said, you start anticipating things, and pre-litigation strategy is something similar. I look at it this as similar to any disease. Once you start sensing in your body that there is something wrong, you want to go and do a preventive checkup so that if something is wrong, then you are well prepared and nip it at the bud, or rather than waiting to become a full-fledged disease and then go into bigger pain. I think this is something similar. What we see is that generally private equity we consider as litigation-averse community, and which is what is apparent right now also here. You don't want to go and fight. You want to rather negotiate and get out of the company than fight. It's no fun fighting. You are in a business of making money. What's the point in fighting? Well, let's get out of it. So that's where pre-litigation strategy becomes very critical, because the way we look at pre-litigation strategy is how do you negotiate an exit while building a case so that in case that negotiation fails, you still have a very good case on for dispute, right? So I think the first thing, as mentioned, you go and approach a lawyer. I think the moment you sense, you don't go and say, there's no dispute, I will wait till the dispute comes in, let me try and negotiate upfront. No, you will negotiate, but take help of a lawyer on how to negotiate. You follow the documentation, right? You've signed an agreement. Most likely when you sign an agreement, you will put it in a cupboard and only bring it out when something goes really wrong. The moment you sense something can go wrong, you bring it out and try to follow a document. For simple reason, one of the most common way of countering your dispute from the other side is doing counter allegation of breach from your side. Your counter allegation of breach, or your breach, supposed breach, comes from not following the documentation. So, you did something, and they will say, you know what, I did something wrong, that's what you are telling, but what about you? You are not coming with clean hands, you are actually done something wrong, and as a result, that has led me to do something wrong. So, you will have counter breaches. So you need to figure it out, what are your counter breaches. You need to minimize that allegation of counter breaches. So that's the second thing you need to follow. The third is, while you're negotiating, build up your case, right? It's very important that when you are going and trying to say, give me an exit or do this, you don't go out and weaken your case. And a lot of time when you're negotiating, you will go down to a case which is acceptable to you, and you will say, I will accept this particular thing, and maybe the negotiation will break down, and the other side will say, you know what, you already came down to such a position, which means you give up some of your claims which you had in the document. So that is something which is critical. Avoid any casual communication. So one of the things which we have seen several times in litigation is a lot of cases are lost because you have something written in a document and you try to enforce that document, but you had either weakened your position or given up your claim because some of the casual communication you have written to them. One example which can come to my mind is, you have an IPO exit, right, and you want company to do IPO. And there was, promoter had written to you saying that, markets are bad. And you said, yes, I agree. Right? Your intention may not be to say that, look, that does not mean you don't go IPO. But what it can be used is that, look, you agreed that markets are bad, so if I'm not going IPO, it's not my fault, right? So be very careful on communication in terms of, what you're trying to say. Sometimes you're trying to say only to make sure that you don't want to appear agnostic or appear conflicted, but, you can do the same thing without actually giving it up. So just that's something which is very critical. I think exercise your rights with care. A lot of time what happens is you have got good rights or strong rights when you entered into an agreement, right? Because you had a good lawyer, or because you had a better negotiating position, or because you were giving money and promoter said, look, I need the money. But once you got the money, if you are exercising, you're saying that I have a right to do this and do that. I don't care what happens to the company, but this is right I have in the agreement. That is something which a lot of courts have looked at it, saying that it's not in the interest of company, and while you're exercising rights, maybe that's not right thing to do. So what we suggest is that when you are trying to exercise a right, always make a case why this exercising of a right is good for stakeholders, is good for the company, is in the interest of the company. So that's an important case you will always try to push, so that the promoter cannot allege that, look, what you are doing is against the interest of the company. That is something which courts are sensitive to. Last point I would want to mention is be very careful on when you want your director to resign. There is a conflict sometimes in the dispute situation. There's always a conflict between the director and the shareholder. Your role as a director and your role as a shareholder, there is a conflict because you have a director on a board. Director is the company. Sometimes you want, you want to go and as a shareholder say, this is my right, but directors may have a conflicting situation. The promoter may say that, look, your director was on a board when we took a decision. He did not object. So a lot of time, your rights which you have used to appoint a director may go against you if your director has not exercised his rights appropriately. So that is something which you need to be concerned about. I think these are just few of the points coming from our experience.
Thank you, Vaibhav. I want to ask a question to Chris, but before that, John, I would also ask you a small question. Let him finish on that. But you got so much experience, and I've seen you since almost 1993, so you'll be able to give some comments as well. And one thing I worked with John in '93. He has a great ability to smell. And I want to ask him, how does he smell things? So if you give me a moment. But Chris, tell me what challenges investor director faces while fund is in dispute with the promoter,
Sure. I guess the first thing is that there's different kinds of disputes. There's the disputes that are resolved. They're what I would call commercial disputes, where it's an adult discussion, and it's a difference of opinion. And then there's the other kinds of disputes, which are probably more in the nature of the kind that cause concern, where the gloves come off and you find yourself in a darker situation. That's where directors sort of may have reason to worry, particularly those directors that are on the ground. There's a number of things. One, of course, it's quite typical, we find this, that the company will often give checks, post-dated checks as security. Those, for example, if they bounce, constitutes a criminal offense, and next thing you know, you can be fighting to keep, to stay out of prison. But more generally, I think it comes back to the first point, that there's the legal system, and certainly, outside of the major centers, the local courts are susceptible to manipulation. And so whilst I think most people, and I think it's right, have faith that justice prevails in the end, what happens is you have a few dark nights along the way. So if you don't have a sense of humor and some patience, frankly, it's probably not for you. I think at the end of the day, again, you need to be armed with the right lawyers. Procedural. It's Byzantine, if you like, the system, But I do think justice ultimately prevails, so it's one of these things you have to sit tight, and you have to not lose your nerve. And I think not losing your nerve is difficult, particularly for those people who are, on the ground in the line of fire. But there's a few things that I think we would do that we think help in a practical sense, and that I think in hindsight is something that is just probably good corporate governance anyway for a majority of the investors, for private equity investors, is, at the outset, to make sure that you have, within your ability, and actual ability, not contractual ability, this is, to keep your hands on corporate records, because corporate records can be manipulated, and if you don't have them, just getting possession of them is a fight that, you can spend a long time over, and it's unnecessary. And so it's one of those things that day one, it's easier to, it's really very much easier to argue about day one than it is, unfortunately, a few years later down the road.
Yeah, in fact, just to add to your point, in one of the cases, Satyam, let me, now it's a public knowledge, so I can talk about it. One of the big problem when the company had this whole thing came up, directors did not have copy of insurance policy. And to get copy from, because how do you go and talk to insurance company? How do you make a reference? A simple thing. But it was so difficult because all board of directors resigned, nobody was responsible, and people are being arrested, and when they are being arrested, how do you really go to a lawyer or law firm or somebody else and claim anything? And that was big problem. So one of the suggestions I have is that if a company has an insurance, please have a copy of it, okay? And it's a simple advice, but you don't know when you need it, because it's always like that. But apart from that, I thought, John, you have tremendous experience, and I thought if you can say a few words on this particular aspect or any other experience that you have, seen, because this is all being recorded and it will be widely distributed. So do not think that some people have walked out, so nobody is listening to you. It's going to be, widely used. So I thought it would be good to capture your views. Thank you.
Thanks, Nishit. I think if I had had the benefit of the comments of the panel before I started investing, I'd have done a lot better job. So the panel's comments ring true, and I don't have much to add, but I think from my experience, I'd say one more thing, which is that if you are a minority shareholder, which most private equity investors are in India, it has to be a partnership between you and the executive management. And it is too easy at the beginning of the relationship when you have the money and the company is desperate to part you from that money to write a very powerful legal agreement that gives you all sorts of rights. But in some cases, that puts you on the other side of the table from the management team, and they are in control, and being on the wrong side of the table from them is not a comfortable place to be in the long term. And if you approach it that you are a shareholder and a partner in the business, and you ask yourself, what can we bring to make this business better? When there are spoils to be shared in terms of gains, it's then seen as fairer that if you've brought something and helped the business get to the point where there is now a gain, that you take a part of it. And that is forgotten sometimes in the approach of investors that seem to think that they should be able to walk away from a business with a great success without having done enough. And I think the issue of partnership is really terribly important. And that's my only comment to add to what has been said before.
I entirely agree with that. Mm-hmm. You have to leave something on the table. Yeah.
Right. So thank you so much. One, I think, last point I just wanted to make, Pratibha, and that is become slightly more relevant these days, and I made a reference to that in the very first part of my talk on the bilateral investment protection treaty. And, Pratibha, could you just tell how do you respond to promoter threats and government disputes, and how do you use BITs effectively in countries such as India, where things have really gone back and forth?
So I think one thing to remember in India is about 75% of the cases are either brought by the government or against the government in higher courts in India. So this is democracy at its best. This is not China. This is, it's almost a matter of your right to be able to sue your government and for the government to sue you back. And a lot of them are tax cases when the government's gone up in appeal. So, when the investors are shy of, going against the government or a government body, it's not really, the central government necessarily. It's usually, one of the ministries or government-owned entity which has co-invested. We have increasingly seen that sometimes the only alternative when it's government on the other side in India is for you to go and exercise your right. Because if you don't, it's not a monolithic entity that is going to take the right decision. The bureaucrats pretty much expect you to go and exercise your right in courts. They actually ask you to go and exercise your rights in court. Sometimes they say, why don't you just go to court if you think, your contract is enforceable? There's not much I can do on this side. And, that goes to the independence of the judiciary, and that goes to the independence of the three blocks of administration in India. With respect to promoted threats, I completely agree with both of you. I think at the first instance, the private equity players do have to make an effort to understand the local nuances of dealing with the promoter in a particular jurisdiction. An Indian promoter might speak English, but he's not really speaking English the way you do. When he says yes, he's just, half-hearted yes, no, yes, the typical Indian, moving your head side to side, you don't know whether he's saying yes or no. So understanding those nuances and understanding your partner is extremely important, but in certain cases, you just can't help it. You've got in bed with somebody who has determined to, cheat you or not return the money, and it's your fiduciary to get the money back. And, we've seen a carrot and stick approach work in those cases. It's, if you wait for the court system to work itself out, as Chris said, the delay is just going to kill you beyond anything else. You will get justice in the end, but not in every case can you get it quickly. So it's when you get those intermittent wins, using then the carrot to lure the investor back. And majority of the cases in India we have seen have been settlements rather than court-won victories. But that's just the fact of the matter.
So, any questions at this point in time? Yes? You can press that button so we can
All
hear
right.
you.
Hi, thank you. I'm Marcela Murzakova with JP Morgan. Thank you very much to the panel and to John for your insightful comments and discussion. Just going back to one of Chris's comments, sort of the recommendation to keep your hands or keep control of the on corporate records. I just wonder, how does it work in India? Because based on my experience in other jurisdictions, usually corporate records must be kept, let's say, at the registered office of the company or business premises or something like that. Are you talking only about sort of keeping copies of everything that's been documented?
No, I think that is right. And so you need to be careful where your company is registered.
India.
Yes, but we have our people, for example, in Mumbai or Delhi, but we have companies in Hyderabad,
Right.
all over the country. They don't need to be there, frankly. You can put the registered office where you want it to be. So there are things you can do, or you can put people on the ground, or you can have a third-party service provider hold those records. There's a number of things you can do.
Or put your own company secretary in place. I have the right to put the company secretary in place. That's very important. I think.
Exactly.
Yeah.
So there are things you can do. It's just that quite often these are viewed as sort of soft issues at the point in time when you're negotiating across the table. Quite often people think, oh no, there's much more important things, commercial. But you can destroy value quite quickly, and the only thing that keeps you from total destruction sometimes, or at least temporarily, are those corporate records.
Okay.
Just to add to what Chris and Pratibha said, I think there are, under Indian law, there are few records which require to be there at the registered office, right? Other records do not require to be in registered office. Not all records are required to be in registered office. Yes, but the key records are required. So what Chris suggested, that you can move the registered office. The registered office is not the same place where the op company resides. It can be at some other place. So if you have it there, you can have a control. I think the second point and the key point here is sometimes when you don't have control, there have been situations where records have been manipulated, and because of the manipulation, some of the rights which you thought you have, you never had. For example, sometimes we have seen in one case which I was involved with, we saw that the company, the way they did the record, they told us they have passed, they appointed a director, our nominee director, but then they changed the record to say that they never appointed a investor nominee director. So if you can't control the record, control the company secretary, because that's the way you can make sure that they cannot manipulate the record. Now, those kind of manipulations are not very common, they are rare, but always it just helps that if you are able to have control on the records or appoint company secretary, in a very rare situation, you don't suffer.
All right. Thank you.
Thank you so much. I think we're coming on to close, but John, would you like to come and say a few words? I really appreciate your participation. Thank you. And okay.
Is this one working?
Yeah.
Hello. I was invited to come and say thanks at the end of this session, and then I looked at the program and saw that I was supposed to be talking about the future. But since I'm standing between you and the cocktails, it's going to be very brief. Okay. I am standing here representing Hong Kong Venture Capital Association. We are delighted that Nishit Desai Associates and the Indian Venture Capital Association have come to Hong Kong to talk about India. We have an association of many of the private equity firms in Hong Kong, and there is a strong tendency of it to focus on China-related stuff. And India is a very interesting investment destination, and there are a handful of people here who are extremely enthusiastic, and my sense is that that handful is growing. So we are very keen to encourage India to be more high profile in terms of the focus of private equity firms based in Hong Kong. On a personal note, I'm also extremely pleased to be on this podium because there are a number of firsts that I have been involved in which are particularly relevant today, in that I used to work for a firm that was probably the first private equity offshore fund investing into India. One of the things that allowed me to do was to be right in at the beginning of the foundation of the Indian Venture Capital Association. So myself and two other people were the founders of that organization. Because we had a tax problem that was horrific, I had a conversation with Nishit many, many years ago where he said, you need to go to Mauritius. I'm not quite sure what you'll find there, but this is the solution. And I think we may have been before the Bombay Fund to set up, but we were just a little private thing. But because of the conversation with Nishit, we solved that problem. And also for Alan's benefit, I was the first person from India. I don't look like an Indian, but I was the first person from India to be invited to the Asian Venture Capital Conference here in Hong Kong in '92 to tell the people in Hong Kong that India was an interesting investment decision, and India actually did belong to Asia at that time because no one had ever showed up before. So for me, it's an honor to be here. In terms of the title that I've been asked to talk about, which is the future, from my perspective, India is a great place to be making investments because there are some fantastic entrepreneurs in India running some really interesting businesses that have the potential for high sustainable growth, and that it is an economy with a lot of potential. Now, we've heard from a number of speakers that all of that has to be couched with a degree of nervousness, that India typically manages to do something just when you think that it's going to be going well, that something goes wrong at that point. And for me, the issues that are of primary importance, and as investors we can really help with a number of these, is corporate governance. We've been hearing about promoter management teams, and ultimately the more that we as investors can bring good corporate governance into those businesses, the better it is for the future of those businesses and for the future of investing in India. The second issue is firms that have been investing in India have to return cash to their LPs. It's all very well talking about the great potential of what you've been doing, but LPs are sitting there saying, we're not seeing enough cash coming back from this destination. So that has to change. I think firms like Nishit Desai and Associates are helping with my third point, which is that regulation and tax still has unpleasant surprises and shocks along the way that is a deterrent for investors. And the fourth point, which we may be heading back to now, is that too much capital kills the investment opportunity. Back in 2007 and 8, to me it was very obvious at that time. I was out fundraising and saying, you know, I'd love to be investing in India, but I don't think this is going to be an attractive time because there's too much capital chasing deals. Then there was a shortage of capital and deals got more sensible again, but we're heading back into a situation where capital is being raised on the back of an interesting macroeconomic story in India, and there needs to be discipline about investing at this time, not too many chasing deals at too high a price. And then I'll just finish on one final note, which is that we've been talking about the efficient tax jurisdictions from which to invest into India. The Hong Kong Venture Capital Association is working with the Hong Kong government to try to create new legislation and new tax such that Hong Kong can become an onshore fund hub, and that funds would actually have a physical presence in Hong Kong and the managers here. And there is a tax treaty with India that is negotiated but not signed, I believe, that would then allow Hong Kong to be competing with Singapore as a jurisdiction. So in thanks for putting on this event this afternoon, which has been a very, very interesting event. What I'd like to say is please don't make this the only one. Come back again next year. And we hope that this will become an annual event, and very much appreciate all the time and effort and work that has been done into making this a successful afternoon. Thank you.
Take it as done.
Okay.
A small formality to, acknowledge thanks to John and Chris and all of you here, including our sponsors. So may I request my colleague Kamal Bhai to just come, and of course, Deepak, thank you so much for our contribution. So if you can, who do we want to give it to? John?
Thank you very much indeed. Thank you.
And this. Thank you very much. Small thing. Yeah, thank you. And
good reason why you have to
Deepak.
come back.
Oh,
We're trying to make sure that
yeah,
this is a
thank you so
real-
much. And we have some of our representatives and sponsors here. So can we have from the sponsor colleagues, Asif Ma or Apriya, AVCJ, if some of you are here, I would really like to have, come on here. Thank you.
Where's Patrick?
Yeah, we would like to, say thank you very much to you.
Sorry,
Just
is
1
Patrick
second.
still around? No?
Yeah, of course. Sorry. Brother, you can give picture, he can take proper. Okay, thank you. And who else? Anyone
No,
else
Patrick,
from?
I think left.
Huh?
I can give them tomorrow.
Okay, thank you so much. So I think we can stand in queue now that we are all here. And anyone from any other organization here? No. Thank you.